And our next and final case for this session is case number 241500, State of Iowa versus Nathaniel Wade Marchant. Here representing the appellant, Mr. Marchant, is attorney Vidhya Reddy. And here representing the state is Ms. Sheryl Soich. And Ms. Reddy, when I know you just were sitting down, but whenever you're comfortable, you can begin your argument.
Thank you. May it please the court, counsel. Mr. Marchant appeals his jury trial convictions, which centered on allegations by the state that he had placed hidden cameras in the bedroom of his live-in partner's daughter and had collected images off of those cameras. His defense at trial was that he was unaware of the cameras, was not responsible for placing them or for collecting the images, and had no knowledge that any such conduct had taken place. On appeal, he raises a number of issues. However, in the interest of time, I would intend today to focus primarily on three of the evidentiary issues raised, although this court is always welcome to redirect me if there's something else you'd like to talk about. So turning first to the court's exclusion of the fact that a topless photo of BT had been found on her own phone. Defendant sought to introduce testimony of this fact in support of his claim that the evidence had been on his phones, the nude photographs had been planted by BT's mother, or her grandmother.
Go ahead.
Can I just drill down on the relevance argument there? I'm having a little trouble figuring out the non-propensity theory of relevance for the victim having the nude photo on her phone. Can you walk me through your theory?
Sure. I think the theory would be that she had herself taken the nude images and collected those and then placed them on his devices, whether remotely or downloaded or whatever. And that because none of the other devices were collected from the house by law enforcement, none of them were preserved, none of them were available to be examined by defense in order to show, that there were any other similar photographs on them. The testimony about the photograph that had been observed by Marchant and Miss Leonard was available in order to substantiate that claim. This was the only photo that he could point to given the state of the evidence.
Any evidence that she ever transferred that photo to anything in the house, any other device, anything like that?
Again, nothing was collected. So certainly he had no knowledge of it that he testified to. But because of the fact that nothing was collected, and he didn't have the ability to do that himself, right? He couldn't preserve that other evidence. He is left only with pointing to this one photo in support of and substantiation of his claim.
Let's assume that she did take a nude selfie, and let's even assume she distributed it to a classmate, for example. How does that make it more or less likely that Mr. Marchant was surreptitiously taking videos of her in the nude from the cameras that that were placed in her bedroom?
So the sending of the photos has no relevance, and defense counsel clarified that he had no intention of introducing that it was shared with anybody sent. And there's no indication that whether it was or not. However, the fact that she had the photograph on her phone would support Mr. Marchant's testimony that the claim that the photographs were planted on, the photographs and images with which he's being charged were planted on his devices by BT either alone or in conjunction with her mother or her grandmother.
I guess that's the step in the logical chain that I'm having difficulty understanding, is how one nude selfie that she may have taken of herself supports the notion that 1,000 images were found on the device where they were found. That's the leap in logic. And not only am I having trouble seeing the relevance, I'm having trouble seeing how it would be an abuse of discretion for the court to say, well, that's too far afield. I'm not letting that in.
With regard to the contrast between the one photo that he can point to and the thousands that are found on his device, the defense is able to make the argument that we don't know that that was the only photo. In fact, he would allege that there were, that there was other evidence of nude photographs that were in the possession of the other family members and indications that they were transferred or moved. But we don't have that because the police never collected the other devices other than those that Mr. Marchant, that were tied to Mr. Marchant. And so,
I mean, boil that down, though. I mean, doesn't it just go to identity then, really? That, hey, it wasn't me that did this. These photos are explained by some other thing. Right? He's saying it wasn't me that took these photos. So it goes, I mean, wouldn't the relevance, at least as I understand the purported relevance, is it's identifying how these photos came to be?
I think that's right in a broad sense. I mean, I think the relevance goes to something, we just have to show it goes to something other than a character purpose, right? And so opportunity, the identity of who's responsible for these, all of those things, certainly are legitimate non-character reasons and reasons not covered by the Rape Shield statute because the photograph itself, without any sort of information that it was shared or was otherwise a precursor to sexual activity, is not itself evidence of prior sexual behavior.
Andy's question, as I understood it, deals with 5404. You're talking about 5412. I was more talking about 5402 and 5403. Did the trial court keep it out on 5403 grounds as well as potentially other grounds? Sorry, I don't remember.
I'm trying to refresh my own memory. I believe they kept it out under the Rape Shield statute 5.412, 5.403 probative versus prejudice, and relevance has to do with both of those. And then I think they also kept it out on foundation. The state does seem to agree on appeal that that foundation issue was kind of dropped, but, or non-meritorious.
Same type of thing, yeah, okay, thank you.
But identity is embedded in 5412, is it not? So the exceptions, so 5.412, under the exceptions, subcategory B1, and then under A, it says, evidence of specific instances of a victim's sexual behavior, if offered to prove that someone other than the defendant was the source of semen, injury, or other physical evidence. So other physical evidence. Would you suggest that this photograph fits under other physical evidence for purposes of the exceptions of the Rape Shield under 412?
Well, I suppose the photographs with which Mr. Marchant is being charged could fit under that other physical evidence theory, namely.
Photo in question.
Well, I don't really, I guess I don't see the relevance or that is because the idea is that the physical evidence is, whether it is tied to the defendant or tied to another perpetrator, right? So in the case of if semen is discovered or condom or something, right? That's usually when we see it. So it's tied to, defendant is charged with this, but actually someone else did it. And so it's the pictures that he's charged with, I think, would be, that the identity of who's responsible.
He was charged with these pictures and he's saying somebody else did it. Okay, and that's where I'm going. So it doesn't have to be semen. My question is this one photo, because the court ruled under 5412, the court said it dealt with it under the context of the Rape Shield, as I understand the record. Did it not, this photograph?
The court gave a number of alternative reasons. 5.412 was one of them, correct?
My question is simply, does this photograph fit within that subsection A's exception as other physical evidence? Can a photograph itself be other physical evidence?
On that theory that it goes to a different perpetrator, the identity of the perpetrator and a different perpetrator. I think ultimately we don't even have to get to those exceptions under 5.412 because the triggering condition for that whole rule to be triggered is that it is evidence of other sexual behavior or conduct of the victim. And we don't get to that because the simple fact that there was a partially nude photograph of BT on her own phone standing alone is not evidence of other sexual behavior. We know from Zeringer that nudity itself photographing nudity is not itself a sexual behavior. And in this case, it was only introduced.
Involve a minor or a child as the subject of the photo?
No, I don't believe Zeringer did. I think it does, because of the fact that really Zeringer's point and the point of the other cases cited on that point, in Kroll and Alberts, the question is, what is this being introduced to prove? Is it being introduced to show sexual conduct, either consent with this defendant, they engaged in this other behavior and that somehow makes consent with this defendant more likely, or other something that's based on the fact of sexual contact with another perpetrator or another individual. And that's not the theory of relevance. That's not the reason it was employed in Zeringer. It was used to rebut the state's evidence that the defendant had asked his fiancée to photograph the victim nude earlier in the night, right? So that has nothing to do with the sexual contact.
You have your time on rebuttal. And Ms. Soich, whenever you're ready, you can begin your argument.
May it please the court. Counsel, your honors, we're here today to ask you to affirm the defendant's convictions for invasion of privacy and sexual exploitation of a minor. And if the court wants me to jump right to the issue that we've been discussing, I would be happy to. What's interesting about this issue, your honors, is that the court did rule in terms of rape shield, also in terms of 403, and kind of that foundational concern as well. But what's really interesting in this case is that the court let in a version of this evidence anyway, and not only did it let it in through one witness, it actually came in through 3 different witnesses. By that I mean BT herself said, there was something on my phone. When they would see things on my phone, they would take my phone away from me. It upset me. Chelsea Leonard, her mother, said,
In that fashion because the trial court made it be limited in that fashion, right?
entirely limited in that fashion, Your Honor, when we get to the defendant's testimony. Because if you look at the defendant's testimony, he, in 2 different instances, says, I looked at her phone, there were images on her phone, there were very disturbing conversations with boys on her phone. That's on page 789 of the defendant's testimony. On page 807, the defendant testifies, in July of 2023, we had issues because she had sent photos to a boy. So I guess my primary point, Your Honors, is that to the extent he wanted to show that this very young victim was sexting, or that she had these photographs of herself, concerning photographs, images, disturbing photographs, he got that before the jury. And again, we have Chelsea Leonard testifying, we have the victim herself testifying, we have the defendant testifying about that. In the opening statement, or I believe it was in his opening statement, the defense lawyer said, you'll hear that she sent photos to a boy. So that got before the jury. And the rape shield considerations were legitimate for the court to at least consider.
Context, the way he said all of that hit exactly on the kind of slut-shaming concerns that were at the core of the rape shield ruling.
Exactly, Your Honor. And he was able to still do that without having the very explicit topless photograph idea. But it might have been very slightly watered down, but it was watered down enough to try at least to protect some of the victim's dignity and integrity without, it still allowed him to put out the idea to this jury, hey, there was a photo, she was sending photos to boys, there were these concerning photos. And
Marie, as far as the offer of proof goes on that excluded evidence, was it the photo itself that was on the phone, or was it testimony about what people saw on her phone?
I believe there was anything with the photo itself, actually. It was Chelsea Leonard, BT's mother, who said, he did show me the photo, I saw the photo, she was topless in the photo. So they were just sort of describing it.
Here's kind of my question with the relevance. The photos clearly that are taken, that were found on the device, she's not like smiling in a mirror like with a selfie. It's clear that these photographs were taken without her knowledge or awareness. So what's the relevance between a photo? Because the way I read the record, the photo that was talked about was that that's what was the photo of, was her taking a selfie.
Your Honor, that's the way I read the record as well.
Does that matter? Like what was found and what's described? Because that's the struggle I'm coming at with the relevance.
Diminishes the relevance, I would say, absolutely. Because when you look at even the thumbnail sketches of the nearly 1,200 images of this 11, 12, and then 13-year-old girl, I think you're absolutely right, Your Honor. It does not appear that she knows that she's being photographed in all sorts of states of undress. Absolutely not. And I do believe that when they discuss the photo in terms of the rape shield issue, that was, this is a selfie. And again, all the testimony bears out. She may have been communicating with boys. She may have been sending a selfie. Not relevant. And again, the court not only made the 403 precursor to sexual behavior argument, which I think the Kroll case is very helpful in that regard, but also just a 403 argument that not very relevant and unfairly prejudicial to this young victim.
Question out of that, because you mentioned the Kroll case. As we're writing up our decision in this case, I wonder, how do we deal with this fitting into the other sexual behavior rubric, which has obviously been a problem for a lot of years in this state about, is skinny dipping inside or outside the circle that we're drawing? Is the state asking for a categorical rule that anytime a minor takes a nude selfie, it is sexual behavior? Is there some other way we should look at the problem? Is it always case by case? Where do you suggest we go?
Your Honor, I think it is case by case. I handled Alberts many years ago. I remember arguing very vigorously about skinny dipping and whether that was sexual behavior. And they were very specific about what did she say during the skinny dipping? What did he say? How long did it last? There was a hug, the boyfriend. They got into the minutia of that. So while a categorical rule might be easy to apply, I would say that we still need to look case by case. Is it an attempt to engage in any sort of sexual activity? Is it any precursor to sexual activity? And again, I think that varies and is very context specific.
Evaluating the context, sort of societally, how things are viewed. You know, I think of when I was picking jurors, sort of what your average juror in the community's reaction to a teenage girl taking nude photos of herself would be. Does that factor into how we look at it?
I suppose you could factor that in, Your Honor, but it's probably difficult to factor that in. I think that the mores of society change at all times. We're evolving always. Things that maybe seem to be slut-shaming at one point are then not slut-shaming at another point. I think that would be very difficult to do. I think, bottom line, though, we just look at, in this particular context, does this appear to be a precursor to sexual activity? And I think that's probably the best we can do.
So that's why we have a district court judge with a lot of discretion to sort of navigate, as you describe it, the minutia that's very context and fact dependent.
Absolutely. And as the Supreme Court has noted a couple of times, and this court has noted, we give a great deal of leeway to the court in making that very decision, the decisions about relevancy, the decisions about prejudice, and the decision, I think, really on what is sexual behavior. That has vexed lawyers, judges for many, many years and probably will continue to.
Where you could wrap up, you could address Judge Sandy's question to your friend from the Appellate Defender's Office about whether the last clause of the exceptions that talk about semen, other injury, or other physical evidence, does other physical evidence include a photograph?
I have must admit, I have never thought of it that way, Judge Sandy. That's a very interesting way to look at it. I think other physical evidence is a broad term, but I think in this particular case, I think they were going for the constitutionally, to the extent they were going for any sort of rape shield exception, it would have been probably the constitutionally required one. I need to show that this photo plays into my defense. I don't think they were saying a photo of a selfie of the victim is something that the state was using to it's usually, as we say, something incriminating, such as the semen or the injuries, that the state is presenting, and then the defendant is trying to say, no, this explains it. It's not me, it's them. But
Of someone else perpetrating the crime, for example, would be maybe some other evidence that exonerates him.
fantastic evidence of exoneration, Your Honor. So I think to the extent that any other physical evidence is not defined, I suppose one could always argue that. Your Honors, I just have 1 minute left. I would urge the court to reject all the evidentiary complaints, but I'd also urge the court to realize that the evidence in this case was really quite strong. There was very compelling evidence of this defendant's guilt. Again, we have 1,200 images on 2 phones over a 2-year period.
Screen grabs of videos. Am I understanding that correctly?
I'm not sure if I would say all. I thought the technical testimony was at some points a little hard to understand. Definitely lots of screenshots, definitely some screen recordings. I think other times, though, it might have been just that they were viewed through the spy cam apps, and then they were, because you'd see there'd be a date of when the video was created. Then a couple days later, there was one instance they talked about specifically where it was a screenshot, and then 2 days after that, they went back and the whole video was saved. It's a little bit difficult to tell. I think most of them were. We would ask that you affirm. Thank you.
Whenever you're ready for rebuttal, go ahead. I'm sure you've heard that one before.
Thank you. Turning first to the state's initial point about other testimony in the record, the problem is this other testimony does not establish that there was a nude image of herself on her phone. There's references to inappropriate images or inappropriate communications, or that she was sending photos to boys. That doesn't establish that they were naked photos, right? It could very well have been
That way because of the ruling about the photo. Did I understand that correctly, or am I mistaken on that?
The sanitized version was with regard to the state's questioning of Ms. Leonard, because that's who the defense would have sought to introduce additional testimony that this nude photo was discovered. And so the sanitized version that was presented was that something concerning was discovered and that her phone was subsequently taken away.
To show motive is she got punished because she had something she wasn't supposed to have on her phone, so they took the phone away from her, so now she's out on a vendetta to frame Mr. Marchant. Okay.
If that was the only theory of relevance, I think the state would have an excellent point in that there was plenty of other stuff about motive, right? The problem is the theory of relevance on which this was advanced and was key and gave it the most probative value was this theory that, listen, she had a nude photograph of herself on her phone. We're claiming that she took these photographs and she herself or in conjunction with her other adults, planted this evidence on defendants' devices. And that in no way comes in, right? There's nothing about that piece that comes in. Even if
None of that came in, just that there's no evidence to support that theory of defense.
I think, again, the difficulty is, certainly from the state's perspective, that's the case, right? That's what the state's going to say. From the defense perspective, it's that we don't have any of the other devices to be able to prove up defendant's defense because the police didn't collect them and we had no power to get them. So how do we show that it came from someone else?
And about, we'll call it lack of investigation as sort of a shorthand. There was nothing prohibiting that in this trial, right?
That's true, but I think it's in context of that the importance of being able to point to this one photograph that was discovered, just inadvertently or whatever, not after the prosecution started. It's important to point to that because Ms. Leonard gives third-party testimony confirming that. It's not just coming from his own testimony, which the state is going to, argue is just self-serving. And it is because of that the probative value of this testimony was extremely high in the context of this case.
Stuck on, how does her having a nude selfie make it likely she planted voyeuristic images of herself?
It makes it more likely, right, in conjunction with his testimony. It doesn't have to be a smoking gun in order to make it be admissible. The jury was entitled to consider that evidence in evaluating Mr. Marchant's claim that this evidence, or that the photographs underlying the prosecution were planted by the others in the house. And, based on this record, all that he has to point to other than this photograph, right, is his denial. And his statement that he didn't do it, and his claims of, the motivation of Miss Leonard and the others, the fact that the relationship was ending, there was going to be a custody dispute with the two youngest children, the idea that there was an incentive to gain advantage in that, right? And so this is the only kind of objective third-party testimony that he can point to in support of that. And when viewed in conjunction with the idea that nothing else was preserved, it makes it more likely the jury's going to conclude, well, yes, that photograph was there. Perhaps there were others that that then support the idea that these were actually taken by BT or her adults and were planted. It doesn't have to be a smoking gun, and it's just something that the jury is entitled to consider, and the defendant is entitled to present for that reason. I would also emphasize that, as I discussed, the probative value was very high. On the flip side, the danger of unfair prejudice was not particularly high in the context of this case, right? In this case, as we've talked about, the jury has observed has heard evidence that there are thousands of images, and that Mr. Marchant is responsible for them. So in that context, it's not likely that the jury is going to be unduly inflamed by the idea that she had a photograph, on her own phone, unless they conclude that that is evidence supporting her responsibility for taking and planting these images. Thank you.
Thank you, counsel, on both sides for your efforts in your briefing and your arguments here today. We found them very helpful. We will consider State versus Marchant submitted, have a ruling out as soon as we're able. And that concludes our arguments for this session, so we stand adjourned. Thank you.